Calling case number 25, RO 04527. This is people of the City of Royal Oak versus Latasha Renee Voss. That's you?
Yes. Sorry. Yes, Your Honor.
Fine. Ms. Voss, you were present a few minutes ago when the court explained the nature of an informal hearing. True?
Yes.
And you understood the court to instruct that you must select from one of three options to protect your rights, correct?
Yes.
Thank you, Ms. Voss. The court wants to make as plain as possible all the parts here, because this is slightly more exotic due to the fact that it was written as what we call a lesser included. So
Yes.
this ticket states that on July 11th of this year at 11:05 in the evening, you were operating a 2017 Infiniti white in color. Now, under the remarks section of your ticket, what Officer Moran indicates is that subject northbound Maine around 5th and made a U-turn to southbound Maine from the right curb lane. So what he witnessed could be written as improper lane usage, improper turn, even careless driving. But what he did do that evening is write this for impeding traffic, which is a 0-point violation and does not mar a master driving record. Regardless of that, Ms. Voss, today is your day in court. So if you wish, you can contest this ticket. So the court needs to understand, do you wish to admit responsibility in this matter, admit and explain, or do you wish to deny responsibility and we'll swear parties and take testimony?
I wish to admit and explain.
Very well. So you're admitting to the court that on the date in question, you were operating a motor vehicle in the City of Royal Oak, and at that place and time, in some form or fashion, you impeded traffic, correct?
Correct.
Thank you. Court appreciates your honesty. What would you like the court to know?
So what I wanted to say, and good morning to the officer as well. What I want to say, the officer was actually behind me. I didn't see a sign that you couldn't make a U-turn. It was dark. So I did go back to that area like a few days later when it was daylight outside, and I still didn't see a sign, and I would never had a turn because the officer was right behind me. I would even, I would never had made that illegal turn that I did right there, but I didn't see the sign, so I wanted to say that. And then when, like I said, when I went back in the daytime, I still didn't see the sign. And then the other thing I wanted to say, far as the payment, if it could be reduced or if I can have time to pay it, if it couldn't be dropped, because I was recently injured from work and I was off work, and I recently just returned back to work.
Okay. Court understands your challenges. Thank you, Ms. Voss. Officer Moran, any brief and helpful hints related to U-turns?
I do know that they are posted on all up and down Main Street, but we'll make it super simple. I'm actually going to dismiss this ticket, Magistrate.
Oh, all right. This ticket is going to be dismissed. Apparently, you're doing everything right, at least post the evening in question. So ticket is dismissed. Welcome back to work. Take care of yourself. Good luck to you.
Thank you so much, Your Honor. Thank you so much to the officer as well.
That's the officer. Big softy. You wouldn't dismiss it for me. I'm telling you that right now.
Calling case number 25 RO 04522. People of the City of Royal Oak versus Jordan Conrad Dowidzenka.
Yes.
Mr. Dowidzenka,
Is it he, him?
you were present earlier today when the court explained the nature of an informal hearing. True?
True.
So you also understood the court to instruct that you must select from one of three options to protect your rights, correct?
Correct.
Mr. Dowidzenka, the citation before the court was issued on July 11th this year at about 10 minutes of 8 in the evening. You were operating a 2022 Hyundai white in color on Washington Avenue at or near Harrison in the City of Royal Oak. And at that place and time, you exceeded the posted speed by a minimum of 1 to a maximum of 5 over. Now that's the citation as written. Officer Moran's detail note indicates a margin of speed of 15 over the posted speed of 25. But regardless, today is your day in court. So as to 1 to 5 over, you may admit responsibility in this matter. You can admit and explain, or you can deny responsibility. The court will swear the parties, and we will take testimony. What do you wish the court to do for you?
I will admit responsibility.
Very well. So you're admitting to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak. And at that place in time, you exceeded the posted speed limit by at least 1 mile over, correct?
Correct.
Thank you, Mr. Doedzenka. Anything you wish the court to know related to that?
I just more or less wanted to show up and see if the court was open to helping me keep my record clean. If that was at all an option. I that's a tricky street, and since then I've gotten a bunch of my friends to even watch their speed on that street, because a lot of people were unaware that that spot is like that. So this was a nice little wake up call. So I've gotten a lot of other people informed, and more or less just wanted to see if there was a way to admit responsibility and see if I could reduce the charge at all. But yeah.
Okay. Court appreciates your remarks. Officer, what would you like to share?
Check his driving record for me, please.
Of course. All right, the court is taking a look at Mr. Doedzenka's driving record for the very first time. And the last citation he received was actually issued on July 4th. Limited access speed in Standish, which certainly sounds like a July 4th weekend Interstate 75 circumstance. And that's all there is.
Magistrate, motion to get amended impeding.
All right, there's a motion to amend to impeding traffic, Mr. Doedzenka. That is a 0-point violation, will not permanently mar your driving record. That's acceptable to you?
Yes.
Yes.
Thank you so much, officer, and your honor.
All right, so the original plea to speeding subsumes a plea to impeding. Fine is $175. That is payable through the pay portal on the 44th District Court website, or you can walk.
Well, him is
cash
a polite
check or
kid.
charge into the 44th District Court, 400 East 11 Mile Road.
I'll give
Monday
him
through
that.
Friday between 8:30 and 4:30, and that is due within 14 days. Please watch your speed.
Yes. Sorry, how do I pay that?
You can pay it over the pay portal on the court's website.
Okay.
So just using your Google machine, or you can certainly
the cop
visit
is
us
super
here at
chill.
400 East 11 Mile Road
He's
between
handing out breaks
8:30
left
and
and right.
4:30, 5 days a week.
All right. Thank you so much.
Take care.
You too.
Yeah. Samantha Harvey never showed up.
Nope.
Okay. I think that might be a sweep for you, Officer Moran.
That sounds like it is for me as well. All I had was Samantha Harvey and she didn't show up. Magistrate, thank you.
You bet. Take care. We should
Officer
see
Blitz
Officer
is here
Blitz
for
around.
his- Yeah, Officer Blitz is here.
All right. Thank you.
Thank you, Magistrate.
Hey, ma'am.
Right,
So I entered a judgment back on September the 2nd or thereabouts, and the writ date was September 12th. And it looks like on September 12th, you filed a motion. Do you have the money to pay this right now?
So my caseworker is working on getting my landlord registered as a vendor to accept the payment, 'cause it has to be directly to him. And then going forward, I'm back full-time at my job, so forward won't be an issue.
I just can't, ma'am, you're not entitled to any more adjournments here. Out of courtesy, I set this for hearing. This was brought to my attention on about Thursday. And I told them to set it for hearing.
Right.
On August the 4th, you came in, said you made the application for funding. I did what I was supposed to do when I adjourned it, and then it was adjourned again from August the 18th. And then on August the 25th, I adjourned it again for another week until September 2nd. You're just not entitled to any more adjournments unless Mr. Trefibio here wants to agree to something. I can't just make my own rules up here.
The reason why the payment hasn't come through with the state yet, I had two parts of my application. So all these were like in the same thing. My DTE and my rent, both I applied for, they did make the payment for DTE, but they can only process one payment at a time.
Who'd you
through
apply with?
SCR. Who's what?
Who, you applied with the DHS?
Yes, directly through my DHS caseworker. And I have the proof of the DTE that was finally processed.
You want to go call your caseworker right now?
Was at my caseworkers last week, and she told me that the only thing that I can take is this, which is the approval, and then.
I can't, ma'am, I just can't do anything. Mr. Trefibio, what would you like to do here?
Your Honor, I'm asking for possession.
They gotta move these along quicker. I can't just extend it forever.
I understand, I truly do, and I'm just humbly asking.
I can't make my own rules. I mean, you owe them $3,500 and that does that include even the $34.99.95? It's a lot of money. How much is the monthly rental rate on this property again?
1,100. So it's July, August. and-
If you get her on, if you tell her to call in or log in, and if she tells me she's gonna get a check to Mr. Trefibio today.
She can't, she has to get him registered. She sent correspondence to him directly to have him registered as a vendor.
Hang on, slow down. Did you receive that correspondence?
Your Honor, I have no idea what that was about. I have not received any correspondence from any government agencies whatsoever.
Right, I was just down there at the end of.
Well, she might have said that. If you want to have her log in right now, she can log in.
It takes hours. I wish I could.
You just can't, I can't.
But it takes hours for them to even
Thank you, Aaron.
answer the phone. That's why I went down there in person. And called off work to go down there.
Can you,
I know, I wish I could give you something more. I truly do.
I know you do, and I feel horrible about this. But the guy has $3,500 owed. He's about to get up to 4,600 on October 1.
Well, that's not gonna happen, because I'm back at work, so I've been paid. I have two jobs. I work at Texas Roadhouse and Greenland Market. Like, I'm fully working again. My foot's fine. They had to process this payment first, which I have and the proof of. And now they need to register him to be able to process my rental payment.
We'll get her.
And that's the course.
They know.
They're sending.
They know. They know how these things work.
They do, and I gave them the judgment date and everything,
So
when I
now,
went
since
back-
you applied for funding before, according to my notes, before August 4th.
I did.
So now you are up to what? 27, 49 days. And they still haven't come through with the money.
Right, for part of,
Wha-
for one part's completed,
DTE is complete.
right,
That has nothing to do with Mr. Trefibio.
right. That's-
Ma'am, I am not unsympathetic. I just cannot ignore laws like this. I'm not gonna do that. I cannot do that. If Mr. Trefibio wishes for me to do that, I will do that. I feel horrible about it. I can tell you're upset. I don't relish in having people leave their homes. That's not a fun thing as a judge. but I can't do it. I really am sorry. I mean, I just am sorry. He's telling me he didn't receive anything from them.
I know, they just did that. So the letter that I received from them, my caseworker. I'm just clarifying, like, the first payment that went out, I didn't even get this until 9/11.
That's the DTE.
Which is the day before my rental judgment was due, so I went down there immediately. It kind of freaked out, honestly, because it's taking so long and I'm gonna lose my house. And she said, well, this is the process we have to follow. Also, we know that your landlord's not registered as a vendor.
Well, why didn't they tell you that 8 weeks ago?
I had no idea. And she said, we obviously checked to see if he could receive payment. He's not registered.
If you think you can go and get somebody on the line right now,
I mean, I could try.
try and then come back in, Mr. Trefibio. I'm gonna ask you to stand by, but they gotta move over there. This isn't, nobody would like not receiving their paycheck. They gotta move. I mean, okay, go make a call. Mr. Trefibio, just stand by for me, will you please? Thank you.
Thank you.
Thank you.
Capital One versus Brian Phillips, 2501456.
Good morning, Your Honor. Cezanne Barta, P 65425 on behalf of the plaintiff.
All right, sir, your name?
Brian Phillips.
Did he ever sign it? It says, I signed it. I said this on August 26th. Parties reached tentative agreement. Defendant has failed to return. 3, I don't know what I can't even read my own writing. 3 documents. I don't know, or proposed conditional dismissals or judgments. Did you send it back?
I don't recall if I did or didn't, to be honest with you.
Okay.
But
have a
right
lot-
now, I'm trying to find a job. I just got.
Do you have a lot of these going?
What's that? Do I have a lot? No, I just said, this is the only thing I know about going. right now.
Did you email or send him the tentative agreement?
I got a paperwork.
Slow down.
Yes, on July 30th, we emailed the conditional dismissal to Mr. Phillips. His first payment was due September 1st and it was never made.
Like I said, I just lost my job.
Slow down.
20 minutes.
Slow down. I have to get this case resolved,
No, and I understand.
okay? So it sounds like you agreed to a conditional dismissal. You didn't send it back. And now you've already violated the terms of the conditional dismissal, which I'm sure according to the conditional dismissal allows them to go ahead and set aside the conditional dismissal and submit a proposed judgment, right? Those were your terms, right?
Correct.
So I don't know what everybody wants me to do here. I mean, you want to enter into this conditional dismissal or not?
I want to get it done, taken care of. I just, like I said, with me.
Listen, we're taking one thing at a time.
I have no problem. I'll get the payment set up. That's.
Come on, he sent it to you 3 times. And then I adjourned it 3 weeks and here we are. Actually, they adjourned it 4 weeks. What were the terms of the conditional dismissal, Mr. Barta?
It is hereby ordered and adjudged that defendant shall pay to plaintiff the sum of $5,589.26 in monthly installments as follows. $100 on or before September 1st, 2025, and $100 continuing on the first calendar day of each month thereafter until paid in full.
You couldn't pay $100?
I lost track of it. Like I said, I don't have a job right now, so I've been out looking for a
Hell
job.
no.
I got paperwork here to show the fact that I've been out looking for jobs. I just lost track and this market right now is an absolute junk pile, so I'm applying for anything and everything under the sun, and not having a job's kind of hard,
Well, I get it.
I have no problem at all. Let's set something up right now. If we can just kind of let that stuff slide, and I'll set the payment.
Slow
up,
down.
Send it today.
Mr. Barta,
Yes.
do you want to try this again with a conditional dismissal of 5,589.26 with $100 per month beginning to be paid on November 1?
If that's what, yeah, that, I have no problem with that. I'm just trying to get a document signed. That's all.
No, so listen, no. I want you to listen to me very carefully. Is that the agreement that the two of you had, 558926?
Yeah,
And was the agreement that you'd pay 100 per month beginning September 1? And do you agree that Mr. Barta, rather than this sending emails back and forth or sending emails that are never sent back, do you have any problem with him signing your name to a proposed conditional dismissal that calls for the same terms and conditions, with 558926 being the balance and the first payment to be made on or before November 1 of 25, and the amount of $100 with $100 a month be paid thereafter until paid in full?
yes.
Hey, slow down. Do you agree to those terms? I'm asking you.
Me? Yeah, I agree with them. I'll go down and.
Slow down, slow down. Does he have your permission to sign your name to this proposed consent judgment?
Correct.
Okay. Does that satisfy you, Mr. Berta?
Yes.
So he'll submit that document order, but you gotta stay on those. You got,
November 1st.
where have you applied at? This job's still all over, I think. I don't know. Maybe I'm wrong.
It's crazy. Like I said, I'm going down to the Michigan, job fair.
Good.
Did the paperwork. I got an interview with, Norfolk Southern. So I mean, like I said, I've got.
Something will turn up. Just keep looking.
Yeah, exactly.
I know it's harder now, but
It will happen.
how old are you?
That's what's that?
How old are you?
56.
When did you last work?
September 29th.
Last year?
No, this year.
September 29th is in a week.
Oh, yeah, I got, laid off on September 29th.
Of 24.
Yeah. So I'm not 24, I'm sorry. It's been about a month and a half. I've been off work.
A month and a half.
Yeah. I've been applying.
Where were you working?
Where was I working?
Yeah.
I was working at a GM factory, zero, for airwork.
Were you entitled to unemployment benefits?
I'm getting 446 a month or a week.
Well, you're better off making 520 a week if you're working than 446 if you're working, but I know some of us don't look at it that way. Good luck to you. That's the best I can do. You gotta find a job. I really wish you well. Good luck.
Yeah, thank you very much for taking care of this for me.
Thanks,
Like I said, that will be done.
Thanks, Mr. Barty. Do you have another one, sir?
No, have a great day.
Hey, you too. Thanks a lot. Thanks. CKS Prime Investments versus Affy Cobbs. 2502297. Mr. Cobbs, your name? Mr. Cobbs, I need you to start your video and state your name.
Hey, Guy Cobbs.
Where is the Mandrich Law Group?
I don't think I have them checked in, Your Honor.
Karen Lowy, you have to take your hat off. I know it's a Notre Dame hat, it looks like. I'm just kidding. But you still have to take it. Okay. All right. They're not out there?
No, I brought everybody in right now and because some
Where
people I
is,
weren't.
Where is did you, I looked at my notes, says you guys reached a tentative agreement. Did you send it back, Mr. Cobbs?
Yes.
When did you send it back?
The same day we had the last court meeting 2 weeks ago, I believe.
Linda, do I have that in my inbox by chance? I didn't sign orders on Friday. Can you double check?
I can check. I'll let you know.
Okay, I'm just gonna pass this for now. Do I have Constance Melvitz versus Chuck Davidson and Chuck Davidson Concrete LLC, 2502422?
You do for the plaintiff side, Judge.
Yes, Your Honor, for defendants.
All right, you want to go ahead and deal with the motion, counsel? Mr. Chesney?
That's fine, Your Honor. Chris Chesney.
Can I ask you a question?
Yes, Your Honor.
It looks like all he did was represent Mr. Davidson in a civil infraction. Is that true or false?
A couple civil infractions, yes, Your Honor, and they were trying to hire him for a personal matter as well.
But they did.
My understanding is no, it never proceeded.
So I'm correct. I just want to be correct. I just want to know that I'm correct on this.
Yes, Your Honor.
You're moving to disqualify Mr. Camilleri because he represented Mr. Davidson on 2 civil infraction cases. Never represented the business though, correct? The business per se?
And that's part of the MSD, Your Honor, because the LLC is.
No, I don't
different
want to
than-
talk about
yeah.
the MSD.
No, yeah.
He says there's a different name on the permit. Whether I grant this or not, I'm going to deny your motion for summary. Discovery doesn't even begun yet. He can amend the name of the party if he needs to. So let's not even talk about your motion for ST. You're
Yes, sir.
telling me that Mr. Camilleri should be disqualified on a breach of contract case between the plaintiff and your client. And there are 2 named, Chuck Davidson and Chuck Davidson Concrete LLC, because he represented Chuck Davidson on 2 prior civil infractions. That's your argument. I just want to make sure I'm understanding it and summarizing it correctly.
Yes, Your Honor, in a general summary, yes.
Well, I don't want to hear general. Let's get specific then. You get specific with me and tell me why he needs to leave. I don't see your point after I read his brief.
Understood, Your Honor. So if you look at our particular motion, you'll note that there were some communications between Chuck Davidson, his son, and Mr. Camilleri for the civil infractions. Yes, but the civil infractions were for Chuck Davidson and the DBA business, Chuck Davidson.
They were for speeding though, right?
I think one was also like a weight thing for the trucking business, which was part of the whole
Overweight
DBA
charge?
situation. I'm sorry?
An overweight charge?
Yes, I believe one was an
Is that true, Mr. Camilleri?
I would suppose so. I know it was a commercial vehicles, but Judge, you know how those work?
I know. This is a breach of contract case, right?
Right.
Your client was hired to perform some cement work, right, for the plaintiff?
Yes.
And the claim here is that the plaintiff, that the defendant did not adequately perform the cement work, right?
Yes.
So you got to convince me. I'm not even close right now.
Understood, Your Honor. I would just advise the court essentially that when this suit came in, my clients were surprised because they had open communication with Mr. Camilleri, that they've reached out to him previously to handle issues such as the citations. So when the suit came in, my client
Might have been surprised. We're always surprised. There's a lot of things to surprise us as we go through this crazy life. But the question is whether he's committing an ethical violation by representing the plaintiff. And I got to tell you, I don't see it.
Judge,
I
I
mean,
know
you-
no more about their business operations than I know about artificially inseminating a giraffe. Okay.
All right. Do you have any basis to believe, well, I don't know if I needed that comment, but you got,
Seriously.
I mean, but this is the rule. A lawyer who has formally represented a client in a matter shall not thereafter represent another person in the same or a substantially related matter in which that person's interests are materially adverse to the interests of the former client, unless the former client consents. This has nothing to do with him learning some business operation by virtue of a attorney-client relationship that might allow him to have an advantage on behalf of this client because he knows the manner in which they conduct their work, and that will make it easier for him to prove that the work was not performed in a workmanlike manner or that they breached the contract. That's the way I see it. I'll give you any other opportunity to respond you want, and then I'm gonna rule.
Thank you, Your Honor. I would just like to note, I think you were referencing professional rule 1.9 about forward clients, correct?
Correct.
Right. And I believe our motion, we were identifying 1.7, which was existing ongoing clients. And that is.
How
kind
is
of-
that an existing ongoing client if the case isn't pending, is it, Mr. Camilleri? You resolved it. It was 2 years ago. It was a traffic ticket, right?
And probably in 15 minutes, I probably resolved it.
Go ahead, Mr. Chesney.
Understood, Your Honor, and that's kind of where, and we've already discussed this about the surprise to my clients, because they've reached out to Mr. Camilleri. They basically had him, what they thought was somebody to reach out on an ongoing basis, which the documents that I attached were attempting to show that. And for instance,
They reach out to him on this case?
not on this case, because the lawsuit was filed and they received it, and they see John Camilleri on the other side. So obviously they can't reach out to him. In our clients.
Notified them in writing that he was going to sue, but go ahead. I don't know.
My office reached out to Mr. Camilleri saying, hey, my clients are, and the emails were in the motion, Your Honor, about, hey, weren't you representing them? And Mr. Camilleri argued, well, he didn't much argue. He just said, I don't know why I would be disqualified. And we identified the fact that on the same day that Miss Malvitz's the work was performed for Miss Malvitz, he was actually in the hearing on behalf of Davidson Concrete, Chuck Davidson, for the citations, the same July 3rd date, Your Honor. So we have this ongoing situation where I understand the July 3rd, 2023, where are these particular dates. So we have this, what my clients felt was an ongoing relationship. There's no end of relationship.
That's not the standard. I don't know if it's a standard. That's not the standard. He has to learn something from his prior representation. If he represented the corporation 3 years ago on a very similar matter, that might be a different story, or 2 years ago. But he didn't. He represented them on a traffic ticket. And it might not be good practice for a lawyer to do this because he upsets people, obviously, as he is your client, but I see no basis whatsoever to disqualify him. The motion to disqualify Attorney John Camilleri from representing the plaintiff is denied. I want to order from you, Mr. Camilleri. I've read your briefs. The motion for summary disposition is dismissed without prejudice. He has the right to conduct discovery and determine who the proper party is. He's given me an argument that a permit was issued to the defendant in his brief. And I think I'm going to just go ahead and deny that right now. I am going to go ahead and deny that right now. I am going to go ahead and now conduct the pre-trial, and then you guys can come back at a later time. Nobody demanded a trial by jury, correct?
We have.
I think a jury
Your
demand
Honor.
was filed, wasn't it?
By who?
Hang on, Judge.
Judge, if there was one filed, I believe you would have it in your packet.
Okay, I just usually see it on the register here. Let me just double check that before I.
Oh, yeah, Judge. I filed a jury demand. I have it in my file. I
Folks,
presume.
hang on a second. Can you please we got signs all over the building. Can you please shut your phones off? Please.
We're starting strong.
I'm sorry. Did somebody demand a jury trial or not? I don't see one.
Judge
Your
Dunn has
Honor,
already had a
I have
week.
one that was filed from Mr. Camilleri's office on June 13th. It was stamped in 33rd District Court.
It's true, Judge. It's stamped at 7:46 a.m. on June 13th.
That's fine. That's fine.
I would request, Your Honor, defense would request an opportunity to actually file a formal answer then as well, since this was a motion in lieu.
All right. What's your P number, Mr. Chesney?
80969, Your Honor.
And I'm sorry, Mr. Camilleri, yours again?
47348.
All right. So we have a jury trial. That's great. How much is this claim for?
$18,000, Judge.
All right, so we're gonna have a settlement conference date. I'm gonna put down 1 day for trial. I'm gonna give you guys, how much time do you guys need for discovery?
I would think 60 days, Judge.
All right. So today is September 22. I'm gonna give you until December 1 to conduct discovery. You have to file your witness list by November 1. I am gonna have you guys file a trial brief, and it has to be filed and exchanged not later than 7 days before the trial date. I
Your
want
Honor,
a
my only
trial.
concern on the discovery is defendant hasn't answered the complaint yet. So he's got 21 days, I guess, to do that, and I'd hate to have the discovery shortened.
Make it
without-
December 15th
Alright.
and witness list due November 15th. I'm gonna say, can you file your answer to complaint earlier, counsel?
If you give us 2 weeks, Your Honor, yes.
Defendants to answer complaint and file affirmative defenses by, I'll just say October the 10th.
Oh, yeah. Jerry will be there.
Okay, and that should give everybody enough time. Now let's set up the jury trial
He's
date.
going to play the Rocky
No
theme song
motions,
for his
by the way,
walk-up
are heard on the
music.
date of trial. All motions in limine and all other motions have to be filed and heard not later than 20 days before the trial date. Why don't you give me one, and I'm not gonna adjourn this, guys, so you gotta make sure that everybody's available. So you guys can pick a date in the latter part of January, early February, and I'll be in, but just understand, I'm not gonna adjourn that. I'll need a
Well,
Friday from you, and I'm gonna have a settlement conference 2 weeks before the trial date, Lisa, or Linda, before you send out the jury notices. So we'll want to have a settlement conference with all parties involved. Your clients are going to have to be here too, Mr. Chesney. I want to do this in person.
At the settlement conference, Your Honor.
Correct.
Yes.
Can we do it on the 23rd of January, the jury trial, and then have the settlement conference? Oh, that would be, let's see. Sorry, Your Honor, I don't have a 26 calendar yet, so I'm using my phone.
You got January 23rd of January
that's-
26th.
Yeah, the 23rd for the jury trial.
Are you
That's
both
a Friday.
available then?
No, Your Honor, I'm in Monroe County Circuit Court for a trial.
Okay, how about the 30th?
Yes, Your Honor.
January 23rd. Are you good on that day, Mr. Camilleri?
I'm good.
January 30 at 8:30 will be the jury trial date. Again, witness lists are due November 15th. Discovery cutoff December 15th. You know what? I'm sorry. Yeah, that should be a good enough. That should be long enough. And then we'll set the settlement conference date. And all parties have to be present in court in person. And we'll set that for like 2 weeks before that. Linda.
How
So-
about January 12th at 8:30?
What day of the week is that?
That's a Monday.
That, let me just check something here. Okay, so I just wanted to double check. Martin Luther King Day is the following Monday, so we'll do January the 12th. January the 12th will be the settlement conference date, and that will be at 8:30 in the morning. And everybody has to be here, okay? Now,
In
I don't
person.
care if you file requested your voir dire questions, but I want to be clear. council shall submit proposed jury instructions and proposed verdict form not later than 10 days prior to the trial date. So you got, I don't care about the voir dire questions.
No, thank you,
But
Jessica.
yeah, you got to submit your proposed jury verdict form and your jury instructions on or before 10 days before, which would be on January the 20th. Okay. All right. Do I have anything else I need to address, ladies and gentlemen?
No, Judge, you're gonna issue an order for discovery though, commencing.
Yeah, we're going to prepare this, and it might take us a couple days, but we will send this out. You should have this no later than Thursday or Friday.
Thank you.
Okay, anything else, Mr. Chesney?
No, Your Honor. Thank you.
Thank you very much, ladies and gentlemen.
Thank you.
Good luck, man. Thank you. Thanks.
Bye-bye.
All right. Who do I have now? Karen Lahi versus Uber Technologies, Inc. 503393.
Yes, Your Honor.
Where is Mr. Lohi? Okay, okay. This is 2503393. This is a small claims case. Your name, sir?
Taran Lohi.
You got to keep your voice up a lot louder than that.
Taran Lohi.
Okay, now you got to stay. I want to be able to see your face during this. And Ms. Munaz, your name?
Karina Munoz.
Can I just ask a question? I'm not sure I understand the nature of your claim. It says wrongfully deactivated from Uber on August 12th, 25 for alleged fraud, which is not true. Rider repeatedly entered same pickup drop-off locations, causing multiple trips. Rider didn't know how to, and then I can't read it. You had ordered an Uber, is that right, Mr. Lohi?
No, I'm the driver, Your Honor.
Rider repeatedly entered same pickup drop locations, causing multiple trips. I don't know what you mean by this.
So when
Why are you
you're
suing Uber Technologies for $6,500?
because Uber was my only source of income, Your Honor.
Yeah, I got to understand your claim, though. I don't understand your claim.
So, Your Honor, on August 12th, Rider
I do.
repeatedly entered a pickup and drop-off location again and again, and Uber sent those trips directly to me, and I have to pick up those trips because if you deny those trips, it affects our rating. And
Okay, so slow down. Now, so you're telling me they were giving you the wrong pickup or drop-off locations?
the rider was putting the wrong pickup and drop-off location, and Uber was sending those trips to me. I have no control over what the rider puts as his drop-off location, and Uber was sending those trips to me directly.
So you're saying, as an example, if a customer went on, and I just want to make sure I understand your claim before we get into this. You're saying that if a rider gets something from Uber that tells them that you're going to pick up John Doe at Comerica Park and you're going to drive him to Mexican Gardens, and and you're saying those were wrong, and you went in, is that right or not? Did you go? Am I understanding this correctly? I'm sorry, I'm struggling here.
Let me explain this, Your Honor. So let's say you were the rider, you were requesting a trip from Uber, and you put your address and where you need to go. If you're putting it wrong, you requested it, it goes through, then it goes to a driver, and driver picks it up. He comes, picks you up, and takes you to your destination. But if the address is wrong, he has to drop you off right there where he needs to, what shows on the address.
I see. I see. Well, how does, first of all, I'm struggling with this because you're essentially alleging an intentional tort. And intentional torts, intentional acts, assault and battery, malicious destruction of property, fraud, those are intentional acts. And you're alleging that they committed an intentional act. And if they committed an intentional act and you're trying to collect, you can't come to small claims court. And so are you telling me that you think that Uber was intentionally telling you to take and put these drive up and to pick up at one location and drop off at another location that the customer hadn't requested, or that they should have known? Or is it because they accused you of some kind of fraud?
I see it more
Because
of
you
as a
were
breach
taking
of
the
contract
driver
claim.
to another location?
So what
But it is
happened was
interesting.
the rider was putting the same pickup and drop off location, and I was getting those trips, and I picked up the rider and dropped him off. And he did
How many
that about
times? Was
5
this the
times.
same driver?
Same rider. 5
Same
times.
rider, that's what I mean. Same rider. I apologize. How many
5
times
times.
did you take that same rider to a specific location?
Same location 5 times.
5 times. And so then what happened?
And Uber paused my account for alleged fraud, and then later they deactivated my account permanently.
Judge Dad is on the struggle bus with this, and it's fun.
Ms. Munoz, what is your position with Uber Technologies?
I'm a paralegal with Uber.
Okay, this is the one I got something on. You live in California or someplace?
Yes,
It's beautiful, cute picture there, by the way.
thank you.
So is there something that can be done here to resolve this? Can I put the two of you in a breakout room and see if you can resolve it?
I've been in touch with the plaintiff, and I have informed him that the deactivation decision is final. So the multiple trips were flagged because Uber sees this as collusion fraud. So it does appear that there was some sort of collusion with the rider to complete these short trip requests.
So you're either saying that so you think that the driver and the rider were in some kind of collusion, as you want to say it, so that Mr. Iohi, am I pronouncing that correctly, sir? Lohi, I apologize. So that Mr. Lohi and him conspired, and the driver would then go to Mr. Lohi would take this passenger to a certain location, but he still had to pay for it, right?
That's correct. It's unclear, since the activity happened quickly and on the same date, and the rider account was created on the same date that these trips occurred. So it's unclear, what they were actually looking to get out of this. But Uber, sees this type of fraud.
Wait. So you're telling me Uber still got their money on these trips, right?
Yes.
Well, how could there be fraud? I mean, how can you enlighten me a little bit? I'm trying to. Listen, I haven't sworn anybody in yet, and I haven't advised you of your rights to have the case removed, because I'm trying to figure out right now if this case belongs in small claims court. That's what I'm trying to do. So I don't mean to sound dense about the whole process. It doesn't make any sense. If Uber is still getting their money, how would anybody possibly benefit by acting in collusion together so that the driver's driving the rider to XYZ location. Let's say that the rider's paying $15 per trip.
That could explain it, Tim. I'm not saying it does,
How would
but it
that-
could.
How would that constitute a fraud against Uber if they're still getting their money?
Yes, I mean, Uber sees this type of activity, pretty often from drivers. Sometimes they could be colluding with the rider using like a fraudulent payment method, and that's how they're paying for the fares. They could be trying to, and in this instance, what our fraud team saw was that the trips were pretty close in distance to the airport. So they could have been colluding to try to get to get dropped off at the airport, because when you get dropped off at the airport, you can get a higher fare trip leaving the airport. So it's unclear what they were trying to accomplish, but ultimately the activation decision is final. And in Uber's agreement that the driver accepted in its community guidelines, it makes clear that drivers can be deactivated for this type of activity.
For Your Honor, airport is about like 20 minutes away where this occurred.
Well, I'm trying to think of how I would handle this. Mr. Lohi, if this was truly your livelihood,
Yeah.
I think you need to get yourself a lawyer and remove the case to the General Civil Division and pursue it there.
Okay.
I mean, if you're capping it at $6,500, if you're truly of the belief that this was a wrongful termination, it seems to me a wrongful termination action you could potentially file in circuit court, and I do not want to proceed here today. I mean, I hear I've got really a wrongful termination and a fraud defense. That's what it sounds like to me. So
It's an independent contractor. I see it more as
In
the
the end,
contract, breach of
all I
contract.
want is my account be activated because
I know,
it was only my
but they don't
social
want to do
income.
that. You already heard her, and I can't force them to do that.
Okay.
They don't want to do that. So I'm going to give you some time to get a lawyer.
Okay.
How long do you think that'll take?
I'm not sure, Your Honor. Probably 3 weeks.
All right. Give me a date if you would, Linda, in about 3 weeks, please.
Okay, how about October 20th at 9:30?
All right. And Ms. Muniz, you can still appear by Zoom now I'm going to come back here. I'm assuming he's going to have a lawyer. If he is, the lawyer's going to have to remove the case. A lawyer cannot appear in the state of Michigan on a small claims case. So they would have to remove the case. And if he does not hire an attorney, then I'll figure out when I'm going to go on that date. But you can still appear by Zoom on that day, okay?
Okay.
As can you, Mr. Lohi. You live in Brownstown, sir?
Yes, sir.
All right. And remind me, you are from San Francisco, right?
Yes, I'm located in San Francisco.
I mean, I just remember when they told me that it seemed like you were in California somewhere. Okay. All right, that's what I'm going to do. October 20th at 9:30. Thank you both. Have a
The
great
Golden Gate
day.
Bridge was a clue.
Thank you.
Thank you.
I mean, that it's a common background, but still, it's a good indicator.
I don't know where I was left on Anthony Cobbs. Why did I not go on Anthony Cobbs?
We were waiting. I checked all the boxes. I don't see any kind of consent judgment or anything like that. We
Okay,
tried reaching
that's
out.
right.
We tried reaching out to Mr. Royce, and we had to leave a message.
I get so tired of dealing with lawyers from Chicago. You know that? It's nothing against Chicago.
Easy
I
now.
don't know if they think that this is a voluntary appearance when they have to show up on cases
Yeah,
here.
kind of.
I don't get it. CKS,
We're
CKS
a-holes.
Prime Investments versus Athy Cobbs, 2502297. Mr. Cobbs, your name again.
Yes, I'm here.
I need you to state your name again.
Oh, 8 Cops.
Did you reach am I correct? You guys reached a tentative settlement agreement. Is that true or false?
That's true.
Did they send you the paperwork?
Yes,
Did you sign it and send it back?
yes.
And you're sure of that? You're sure you sent it to the correct email address and everything?
Yes.
The paperwork. Send it back. I'm gonna adjourn this 2 weeks to see if we get paperwork back. If none received, and plaintiff counsel fails to appear, case will be dismissed. That's it. We're gonna give you another date, October what again?
That'll
6th
be October 6th at 10 o'clock.
at 10 o'clock. That's it. Thank you very much. Have a good day.
Thank you, you too.
I'm going to do Gregory Smith. Is Gregory Tyrone Smith out there? Junior? 25W8373928. And B and C. All right, detective, your name?
Detective Davis, Woodhaven Police Department.
Mr. Smith, your name?
Gregory Smith.
Was he given a lawyer?
Names is up there.
Oh, Mr. Haynes, I need you. Call Mr. Haynes, please. This is what happens, Mr. Smith. Your name?
Gregory Smith.
Yeah, we send them to the judge and we have to wait for a response from the judge. When is your
I need to hear what I need. Do I have a sheet on him today?
There's nothing. I called his extension, it's not in there. Text him.
Just bear with me, detective. We can't find the lawyer. Ford Motor versus Talira L. Mosby, 2501052.
Good morning, Your Honor. Deborah Winslow, P 63179 on behalf of the plaintiff Ford Motor Credit Company.
Morning. Ma'am, your name?
Talira Mosby.
This is just a pretrial. Have you guys talked to Ms. Winslow?
We did, Your Honor, and we have reached a resolution. If I
Okay, you
put
can
the
put the
terms on the
terms on.
record. Sure. We've
Not-
agreed.
Just nice and loud.
Oh, okay. We have agreed to resolve this matter for a conditional dismissal with a payment plan. We've agreed to $8,000 to be paid in monthly installments of $100 beginning October 28th, 2025. Should there be a default in the payment arrangement, we would submit an affidavit of default and then seek the amount prayed for in our complaint, $9,537.63 plus costs at that time, less any payments made pursuant to the agreement.
Ma'am, do you understand that and agree to that, Ms. Mosby?
I understand and I agree to that.
So they're praying for 95, 37, 63, which is obviously $1,537.63 more than the settlement is. So it behooves you to pay this. If you pay every payment of $100 beginning October the 28th of the 28th of every month thereafter until paid in full, the case will remain dismissed. If you fail to make a payment, then the judgment will enter for their 953763 plus court costs and attorney fees, which will total another $400. They'll submit an affidavit. A judgment will enter in the amount prayed for, 953763 plus costs, less than any payments made. Do you understand that and agree to that?
I understand that and agree.
Does Ms. Winslow have your permission to sign your name to a proposed judgment or a proposed conditional dismissal order?
Yes.
Do you have any questions at all?
No.
Okay, Ms. Winslow, thank you very much. You can submit your order. I appreciate it. Have a good day. Thank you.
Thank you, Your Honor. I do also have her email address, so I can send her a copy just to.
Okay, perfect.
make
Thank
sure.
you.
All right, thank you. Have a nice day.
All right. I'm going to take this Smith, Gregory Tyrone Smith Jr., 25W837. 392 A and B and C. Mr. Smith, your name again?
Gregory Smith Jr.
Detective Davis.
Yes, sir. Detective Davis, Woodhaven PD.
Haynes.
Good morning, this is the court girl, Inspector Gregory Smith Jr.
All right. So he has a drivewall suspend. He has a no insurance. He has an expired plate. He went into default on those. How is he going to proceed on these?
The default ones, they'll plead guilty to failure to pay.
If you plead guilty to
Well,
those, sir,
That's something.
213 and 282 are owed plus a clearance fee. You could get 1 day in jail for every $10 owed if I find you could have paid and didn't, and your failure to pay was not without your fault. So you could get 29 days on the no insurance, but you can satisfy that in full by paying the 282, or you can pay the 213 on the expired plate, or have to serve 22 days on that case. Do you understand that?
Yes, sir.
You have the right to a hearing as to whether or not you failed to pay. At that hearing, you have the right to bring in your own witnesses, to use the subpoena powers, the court to bring in those witnesses, to testify or remain silent. If you remain silent, that silence would not be held against you. If you plead guilty or are found guilty of failure to pay, you could receive the penalties as described. Do you understand me?
Yes.
Thank
You
you.
wish to have a hearing or you wish to plead guilty?
I think my lawyer was saying plead guilty.
That's what he said to me. I just want to make sure that's what you want to do.
Yes.
To the charge, you failed to pay $213 on the expired plate charge. How do you plead?
Plead guilty.
To the charge, you failed to pay 282 plus your clearance
We
fee,
didn't
which
get
I'm not
lucky
going to
here.
imprison you for. How do you plead to failure to pay 282?
Plead guilty.
Anybody forced you to plead guilty?
No.
And you agree that you owe the money, right?
Yes, sir.
So I'm going to accept your pleas. My issue with you is, for whatever reason,
Okay.
I guess you showed up here
Yes.
initially for arraignment.
Yes.
We gave you a new date on March 19th because you were here March 5th, but you were waiting in the hallway for some reason. We gave you a new date on March 19th. You didn't show up. We rescheduled for April 2nd. You didn't show up.
Yep. I was sorry. The day I showed up, the day I was in the hallway, I was approached by the lawyers saying that the judge had left early. So that's the
Well, I
reason.
didn't leave that early. You must have been sitting in the hall instead of coming into the courtroom, but I don't care about that. You didn't show up again.
Yeah. I just was having issues. That's all.
Where does he work?
Woodhaven staffing.
I even staffing.
You got a good job. How much you make there?
I make 30 an hour, but I was
Yeah.
just telling my lawyer I'm single parent with 5 kids with a girlfriend. So it's not no excuse. I'm just trying to balance my finances out. That's all. So I was just,
You can't just ignore courts. You mean to tell me you've been about 1.5 miles to 2 miles max from here, coming to work every day for 7 months, and you haven't bothered to show up and come in and take care of your business?
I've been trying to, but I've been catching.
Why, did
Ubers.
somebody stop you? Did somebody prohibit you from driving over from Woodhaven Stamping one day? I mean, you tried to and they blockaded the road so you couldn't drive over? Come on.
No, sir. It's just before I got a car, I was Ubering back and forth to work. So it was a money thing. It wasn't. I was just trying to manage my money. It's on me. It's my fault. I take sole responsibility. I should have managed my money right and handle my business right.
I'm going to set a pretrial September 24th, 10%. That's ridiculous. You got the money to pay this. You figure it out. You do a better job managing your bills. 2,010%. You think you can pay that?
Can I pay it? Am I able to pay today and get out today?
Yeah, I'll let you do that, but you got to show up on Thursday.
I will show up,
Wednesday.
sir. You will see me first thing in the morning.
Do we have Brownstown? You can post. I'm going to set it for October 1. That's if you couldn't post. You're sure you can post, right?
Positive.
All right, October.
What was it? 300?
So he does have money.
200.
200. Okay, yes, I'm positive I can do that.
Don't jeopardize that job. A lot of guys would like that job.
That's why
Mr. Haynes and I may be included, right, Mr. Haynes?
That's why I say it's totally my.
Man, $45 an hour on Saturdays and, huh?
That's why I say it's my fault, Judge, because I should have handled my responsibilities better. And literally, I
sound like you're running for Congress now.
No, because I'm a good kid, so I understand my responsibilities.
I can tell you're a good kid, but you got to act like it, okay?
Exactly.
Talk is cheap. You seem like a real nice kid. I'm glad you can post. October 1. What time do you work? You work days or afternoons?
No, I work nights, 11 to 7 in the morning.
I'll tell you what, we'll make this earlier for you on the 1st, so you don't have to wait around. They wrote down 10 o'clock. I'm going to make it 8:30. Okay? 8:30 in the morning on October 1.
That's perfect.
All right. Wish you well. I doubt you'll qualify for a court-appointed lawyer. You can fill out a petition for one if you want.
Okay.
But how much did you make last year? $80,000?
Nah, I don't think I was that close. Probably a little bit lesser.
And including your bonuses or?
No, TLO last year, so I was on TLO a little bit.
You fill out your petition. You be honest with me. We'll go from there. Okay. Good luck.
Okay. Thank you.
All right. The Hamptons versus Amnicon, Saline Con, Santa.
All right. I got a nugget from Zach. I want to see. He sent this to me midstream here, but it sounds pretty good. Let's check it out.
There are still folks out. Thank you, Margaret. There are still folks lined up outside. I just have some housekeeping I wanted to go ahead and do because, again, we're waiting for all of the jurors and defendants and witnesses and everybody else everywhere to get in and get ready. First thing I need to do is the direct contempt hearing for Xavier Jones. Mr. Jones, deputies, y'all may bring him up to the podium. Did I get ahead of Piper? Oh, I got ahead of him. If you'll just bring him up to the podium and then. Thanks, Deputy White. Okay. Placing you under oath, do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? All right, do you? You've nodded your head twice, but I need you to answer out loud for me.
I do.
Okay. Mr. Jones, you are Xavius Rashard with an A, R-A-S-H-A-R-D, Jones, is that correct?
Right.
Xavius, Z-A-V-I-O-U-S? Yes?
Yes.
Okay. Mr. Jones, you and I have already met because I don't know if you've noticed, but today in this courthouse, we have a lot going on. We have 100+ jurors here for Superior Court, which this is not Superior Court. We have dozens of jurors here for State Court. We have court going on every floor. We've got 30 people outside the courthouse doors just trying to get in. And frankly, I needed today to go very smoothly. I needed everybody to do what they were supposed to do, when they're supposed to do it, the way they're supposed to do it, so that we can get started. And you are the one who has made that not happen. And so that's why we're having what's called a direct criminal contempt hearing. Because I got a call that said, I have a juror who smells so badly of burnt marijuana that we can't breathe down in the jury room. So I said, well, there's only one way to know for sure. So I got on the elevator with Deputy Piper. I went down. I called you out of the jury room, which I immediately caught a whiff of it. But man, when you and I got in the elevator together and those doors closed, I could taste it, the smell.
If you didn't know, y'all stink. Okay, that's just my opinion.
Was so strong. You also are wearing your pants in a way where your underwear is showing, which is not appropriate for court, but I'm noting that as a side point. The marijuana is my main issue here. So here's the deal. You may provide testimony if you wish, but you're under no obligation to do so. As this is what's called a direct contempt hearing, it is me saying I saw this thing that disrupted the orderly operations of this court, because instead of calling this calendar and managing this, and instead of the clerk's office downstairs managing the jurors and getting everybody out the door, they were at a standstill because they were overwhelmed with the smell of marijuana downstairs. To which I know it came from you, because A, it doesn't smell like that anymore, is my understanding. And B, again, you and I rode the elevator up and it was so strong I could taste it. Do you wish to provide any evidence in your defense, or do you wish to remain silent? Silent. Okay, good call. All right, well, in that case, I will ask you one last question, which will let me know which way I want to go. Do you admit or do you deny that you smell of burnt marijuana?
Deny.
Okay, it's 20 days to serve in the Spalding County Jail. You can take him downstairs and order will follow.
Ooh.
That way.
You may appeal this. You have 30 days and you have 6 months to use your habeas rights.
I love it.
All right, we're back off record while we're bringing new folks in.
All right. I think we're gonna leave it there. That was a lot of fun. Thank you, Zach. That was some quality entertainment for the end of that stream. That stream was weird because I thought we were doing the potted plant lady. Apparently, I got the day wrong, which is fine. Because it all worked out. Because we had artificial giraffe insemination and a weird Uber case, and a dude getting rung up for smelling like dope when he showed up to jury duty. I mean, it all worked out in the end. Oh, thank y'all for coming out. I got to button up my shirt and go to court. So that's it. I thought I was going to squeeze in the case. I think it might be up tomorrow. I'm told in the chat that Clay Township is having a meeting tonight. Although I usually don't get that right away because they don't put it on YouTube till the next day. I think that meeting can be viewed on Facebook, but I don't know how. I don't know. I'll talk to my people. See, I'll when I get it, we'll put it out. All right. Thank y'all for coming out. I will see y'all soon.